Madam, you will recall that your case was postponed for judgment. The court will proceed to note judgment. This is a judgment in a bail application wherein the applicant is accused number 3, Noxolo Phindela, residing at Ramhlakwana. She is 27 years of age. Charged in a case of murder which falls under provisions of section 51(1) of the Criminal Law Amendment Act 105 of 1997, as it is premeditated murder. Applicant is represented by Advocate Matebula, bail Matebe. I'm sorry, Matebula's case. I'm sorry. The bail proceedings continued in terms of section 6011A of the Criminal Procedure Act 51 of 1977, as the offence is listed in Schedule 6 of the bail legislation. In terms of this legislation, applicant is to adduce evidence either orally or by way of affidavit or submitting any other admissible evidence to satisfy the court that exceptional circumstances do exist which may, in the interest of justice, permit a release on bail. The defense opened its case by calling the applicant to give evidence as to why she wants to be released on bail. And the court will not repeat all the evidence as it appears on record. Amongst the evidence, to testify that she is employed in Johannesburg and wants to go back to work. Resides with her little brother and cousin, wants to go and look after them. That she also supports them financially and also takes care of the house. And that if she is released, will abide with conditions of bail and will be safe, as she will not be staying in Maluti or Matatel. She will be staying in Johannesburg. Will come and attend the court case when called upon to do so. The defense also called another witness, Susan Wabisa, and her evidence will not be repeated. She confirmed that she's a cousin of applicant and that from 27th till 29th December 2021 they were at Aikopo with applicants at a ceremony. The state opened its case by calling the investigating officer 1, Mr. Ponza. Testified that he is opposed to the release of applicant on bail. Reason being that he informed the applicant telephonically that she's implicated in a murder case at Maluti and wants her to travel to Matatiel in order to make a statement, but she did not come. The investigating officer tried to make several attempts to call her, but the phone was then answered by some male person who said it is the wrong number. He then had to make a plan of traveling to Johannesburg to try and find her. Traced her until she found where she works and found her, and that is how she got arrested. You also did go and verify where she resides. The court will not repeat other reasons because it has then found that this is the main reason for the opposition. Also, arguments will not be repeated. In the case of Pro, then 2004, volume 2, SACR at page 242, in determining whether or not a bail applicant has established the existence of extraordinary circumstances, in determining whether or not a bail applicant has established existence of extraordinary circumstances, within the meaning of section 6011A, the court has to make a decision on the facts judged within the context of the particular case. Facts judged within the context of that particular case. Facts which might be sufficient in one case might not be enough to warrant the grant of bail in the particular context of another matter. In bail proceedings, the question is not about the guilt of an accused. But whether the interests of justice permit the release of an accused on bail. The court in this bail application has heard the evidence of the applicant and her reasons why she applies to be released. Also heard the state reasons for opposition. And the court arrives at a conclusion that there are exceptional circumstances that had been accused in her evidence. Which certify the court that it will be in the interest of justice that she be released. Subject to the following conditions. The accused attends court whenever the date is given to her to attend at 8:30.
ukuba ummangalelwana naye na usuku okanye umhla kuthiwe aye enkundleni aye khona enkundleni abe khona ngo-8:30 ekuseni sele ekhayana.
That the accused person not to interfere with any witness for the state in any manner, not to contact them or go to anywhere near them.
Kuba ke okwesibini awuzuphazamisana namangqina nophando lombuso kweli tyala, awuzukuya nalapho bekhona amangqina.
Not to interfere with police investigation.
Ungaphazamisani nophando lwamapolisa.
To sign once a week at the nearest police station where you reside between 8 a.m. to 5 p.m.
Ngoba ke usayine kwi-police station ekufutshane nawe kanye ngeveki, rhoqo iveki neveki, phakathi kuka-8 wasekuseni no-5 wasemalanga.
To surrender her passport if she does have one, as I don't recall, and I tried to look in the evidence, but I could not find whether she has or not, but to surrender if she does have one.
Uba ngaba ikhona ipassport nayo unikele ngayo emapoliseni.
Not not to leave the country of South Africa until the case is finalized. Not to commit any other offense. And as your advocate had said that your bail amount may be set at any amount, your bail amount is set at the amount of 30,000 to secure attendance in court. And if you pay the amount of bail, as you have already been given the conditions, if you fail to adhere to any of the conditions that you are given, then your bail can be cancelled and your money can be forfeited to the state. Let's stand up for now. one. Now number 2, if you remember, was is withdrawn. So now it will be like it is just any 1, 2, 3, 4, 5.
It's going to move application for 2, 4, and 5. We have arranged that the matter will postpone to Tuesday the 28th for them to move the application.
Worship, I confirm and claim the of accused number 2, 4, and 5, your worship, and I confirm, your worship, that we will proceed with the bail application, your worship, on the 28th of June.
You will give us appreciate that other actions who are frustrated. That is accused number 1. There's going to come before court on that day, as we are going to deal with the bail application at the date on the date. Then on that day we will postpone for
2, 4, and 5.
32.
So, please, Worship, for the record, Worship, so that the record may not be confused. On the previous occasion, Worship, on the 24th of May, accused number 1 was represented by Mr. Tanamata, of which the court may recall that I was also present when I was brief for the day. Today, I'm placing myself on record for accused number 1 and 3. Your Honor, I will not have an objection per se, but just a few issues that need to be highlighted. We were advised on the day that the High Court prosecutor, if I'm correct to say, asked that this matter be postponed for 4 weeks, and to be exact, and that was done after bail was refused in respect of accused number 1. May it be noted, so that you should, on the following day, we do not fight on the following postponement. You said recess 2 weeks. I believe 2 weeks from today. Which is the 5th of July. The date is open with me.
If I like
Okay, I'll do it shortly. I'm still noting. So, Mr. Matera, so you said that I did not hear you well. Since now the date is not available, then what did you say?
I said, Your Worship, I will suggest the 5th of July, Your Honor, which I believe it's a further request from the state. It's been postponed for 2 weeks. I think that 2 weeks ends on the 5th of July.
It will be that other week. Because we are in the middle now of the first week, so we cannot say it will be the 5th. So if it's 2 weeks from now to next week, will be from today till Tuesday, next week is the first week, then that other week, the 12th, will be the second week.
It is not.
Yes, I was going to suggest that the 12th of July.
Oh, you wanted to say that?
Yes, I wanted to say
Oh, okay, fine. So your case is postponed in twofold for number 1 and number 3. Your case is postponed to 12th July 2022 for High Court date. So we will remain in custody, number 1, number 3, until payment of bail. Number 2, 4, and 5, your case is postponed to 28th June for bail application. Will be in custody.
Ngiyalangelisela umhla ka-12 July. Imiselwa ufake umhla wokuya